Hello, everybody, and welcome to History/Law Bite number 141, dated December 26, 2020. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled Ableman versus Booth, 62 U.S. 506, 1859. Ableman versus Booth was a very important federalism case decided in the 19th century, not long before the outbreak of the American Civil War. It was a test, a battle of wits, if you will, between the authority of the federal courts versus the state courts, okay? And who was going to be more powerful, who was going to win, who was going to carry the day, all right? So before I get into the facts of Ableman versus Booth, allow me to provide you with some context of this era. This case was decided in 1859. The Civil War, of course, broke out a couple of years later. The 1850s were a very, very divisive period in American history. If you think we're divided now, go back then. The slavery question, all right, had become the dominant issue in American politics. As a matter of fact, no issue since that time has been more divisive than slavery, okay? It was one that literally tore apart families, destroyed friendships, okay? Literally caused governments to fracture, all right? Where you stood on slavery might often determine whether or not you keep standing at all. Yes, it was that real, all right? The slavery question threatened to tear America apart several times in the 19th century, well before the outbreak of the Civil War in 1861, okay? So, in Ableman versus Booth, we see slavery issue bear its ugly head, all right? In this case, it was in regards to the enforcement of the Federal Fugitive Slave Act of 1850, okay? In Ableman versus Booth, Mr. Sherman Booth, all right, had sought the release of a local runaway slave named Joshua Glover, who was being held in a Wisconsin state jail. At that time, the federal government regularly housed its prisoners in state correctional facilities, all right? Well, correctional facilities is a bit much. State jails, okay? And Mr. Josh Glover was no different, all right? So Mr. Booth sought a release, a writ of habeas corpus, release for Mr. Glover from the jail, all right? Even though Mr. Glover was a federal prisoner. And the Wisconsin state judge granted the writ of habeas corpus ordering Mr. Glover's release. But the federal authorities would not cooperate since this is coming from a state judge. 'Tis no matter, however, as a mob soon forced the release of Mr. Glover from the jail, all right? So with that action occurring, Mr. Sherman Booth was arrested and charged with violating the Federal Fugitive Slave Act of 1850, as he had directly aided in the actions of a fugitive slave, a runaway, all right? So Mr. Booth was detained. He himself sought a writ of habeas corpus to be released from federal custody, but he sought that writ from a state judge in Wisconsin. Seeing no issue with that, the Wisconsin state judge issued the writ of habeas corpus, freeing Mr. Booth from federal custody, all right? The federal marshal appealed the writ to the Supreme Court of Wisconsin. The Supreme Court of Wisconsin affirmed the writ of habeas corpus and boldly declared the Fugitive Slave Act of 1850, a federal law, to be unconstitutional. So, with that in mind, Mr. Ableman sought relief from the federal courts, all right? And accordingly, excuse me, Mr. Booth was once again re-prosecuted and sentenced to confinement by the federal judge in Wisconsin, all right? The U.S. District Court for the District of Wisconsin, all right? Once more, Booth appealed for a writ of habeas corpus from the Supreme Court of Wisconsin, which emphatically ordered his release once again and once again declared the Federal Fugitive Slave Act to be unconstitutional. All right? Follow me so far? Great. So the Supreme Court of Wisconsin had directly nullified the decision of a federal court. Basically, we, the Supreme Court of Wisconsin, are telling the U.S. District Court for the District of Wisconsin, kick rocks. We own this here. You don't matter. Bye-bye. All right? So, a state court has overturned the ruling of a federal court. Not something you see. All right? That is very, 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 very just off. You know, it's just, it does not happen, folks. And of course, in the 19th century, you might have seen anything, but today, no. All right? So, the Supreme Court of Wisconsin, all right, has a lot of nerve here, as you can imagine, all right? They're really asserting their power in the state, okay? And when the matter was appealed to the Supreme Court, okay, of the United States, in spite of a direct request by Chief Justice Roger B. Taney that the record be sent up from the Supreme Court of Wisconsin, the Wisconsin Supreme Court said, no, we're not sending you anything. Okay, so the Wisconsin Supreme Court, you know, for all intents and purposes, is gangster right here. All right. Not only are they overturning a decision of the U.S. District Court in Wisconsin, but they're basically telling the Supreme Court of the United States, we're not sending you anything. Make us. All right. Hey, it's the 19th century. You saw a lot of crazy stuff back in that time period. All right. So the Supreme Court had to decide this case without the official record, all right? So the question essentially presented to the Supreme Court was, did, all right, the Supreme Court of Wisconsin have the authority to issue writs to free Booth from federal confinement? And the greater question presented essentially is, can a state court issue writs of habeas corpus to release someone held in federal custody? All right? So with that in mind, that those questions presented to the Supreme Court of the United States, the court, in a unanimous decision issued by Chief Justice Roger B. Taney, ruled absolutely, positively, indisputably, no, they did not. The court held that the Supreme Court of Wisconsin, and effectively the whole Wisconsin judicial branch that had engaged in these actions, were entirely out of line. Okay? The Wisconsin courts were out of line. Totally out of line. First of all, state courts under the Constitution do not have the power to overturn the judgments of federal courts. All right? The federal government under the Constitution has the authority to enforce its laws via its own courts, okay, without, quote, interruption from a state or from state authorities, okay? Article 3, Section 2 of the U.S. Constitution obviously grants the federal courts the authority to hear cases arising under the Constitution and laws of the United States of America. And the Supreme Court of the United States has appellate jurisdiction to hear those cases, all right, once they have been decided by a lower federal tribunal, all right? So, and of course, under certain circumstances, state courts, okay? Federal courts, as we all know, operate completely independently of state courts, all right? and thus federal courts are able to execute federal law through themselves, okay? Federal courts have the ability, thus, to interpret and apply federal law, okay? Oversee the execution of federal law, okay? If states had the final say to do this, assuming there were no federal courts, it would obviously be a breeding ground for pandemonium and confusion over the interpretation and meaning of federal law. Each state would be interpreting federal law differently, and its application would be different in every single state. Thus, federal courts are independent of the state courts and have the ability to interpret and apply federal law according to their own respective perspectives. Last but not least, all right, the Supremacy Clause located in Article 6, Clause 2 of the Constitution clearly gives federal law supremacy over state law when the two should come into conflict. With that in mind, federal courts have the final say on the interpretation and meaning of the U.S. Constitution and all other relevant federal law, okay? State courts cannot interfere with federal courts, okay? State courts do not have the ability to overturn or nullify the decisions of federal law, okay? No way, no how, all right? Federal courts have the final say on the interpretation and meaning of the U.S. Constitution and all other relevant federal law, and the state courts cannot interfere with them in their operation or abilities. State courts cannot overturn the decisions of federal courts, okay? The Supremacy Clause effectively prohibits that action. Federal courts and federal law being supreme over state courts and state law, all right? Federal courts have the final say. State courts do not. And as in this case, the Supreme Court of Wisconsin, which is a state court attempting to overturn and declare a federal law to be unconstitutional, in this case, the Fugitive Slave Act of 1850, that action was absolutely illegal under our system. A state court with all those other things in mind does not have the authority to declare a federal law unconstitutional. That is the exclusive province of the federal courts. Okay? Thus, Booth's conviction was affirmed accordingly by the Supreme Court of the United States. All right? And this decision obviously punched the wind out of the Supreme Court of Wisconsin in its ever-inflated ego to attempt to undermine and overturn a decision of a federal court. So, what do we get from this case? Quite simply put, the holding of this case tells us that the federal judiciary has the final say on the interpretation and meaning of the U.S. Constitution and all other relevant federal laws. State courts do not have the authority to interfere with the operation of federal courts, nor do state courts have the authority to overturn or nullify decisions from federal courts, nor do state courts have the authority or ability to declare a federal law unconstitutional. Okay? That is the province of the federal judiciary. Okay? Now, it is interesting that in this case, Chief Justice Taney speaks of broad, robust federal power against that of state power. Okay? When in Dred Scott 2 years earlier, he all but decimated federal power against local power, essentially, with the only real issue being different was which side was on the side of slavery. In Ableman versus Booth, the federal government was on the side of slavery, which is why he broadly speaks of robust, untouchable federal authority that these Lilliputian states dare not interfere with. All right? Whereas in Dred Scott, Tawney reduced federal power to being barely there with respect to regulating slavery. As a matter of fact, he declared it all but non-existent. Okay, he all but destroyed the ability of the federal government to restrict or prohibit slavery. So when the federal government was trying to restrict or prohibit slavery, oh no, they don't have any power whatsoever. No. All right. Slavery is a local matter. Federal government doesn't have any power to interfere with it then. But when it comes to promoting slavery, as via the Fugitive Slave Act of 1850 in Ableman versus Booth, oh yes, federal government must be allowed to operate. They have broad, strong, untouchable authority to enforce their laws throughout the United States without any interference from the state governments whatsoever. Okay, so over Tawney, it all depended on the issue. Make no mistake about it, he was certainly a states' rights guy. The only reason he's speaking like John Marshall or Joseph Story in great platitudes of broad federal power is because the federal government here was seeking to promote and protect slavery. That is it. Though we sympathize with the Wisconsin Supreme Court in doing everything it could to undermine a very unconstitutional and draconian law, the Fugitive Slave Act of 1850, the decision nonetheless in the Ableman versus Booth was a good one. Because, hear me out, because in the same way, if the Supreme Court had allowed a state to undermine federal law here, in this case a bad federal law, what would stop them down the road from, the situation being reversed in the future, whereby a state was trying to undermine a good federal law? Let's say that the court had ruled differently in Ableman versus Booth, that Wisconsin, sure, you guys can overturn a federal law. Go ham. Do you. Okay. Because this was a bad federal law, we don't see a problem with that. But let's fast forward 100 years. With the passage of the Civil Rights Act of 1964, what if, let's say, Mississippi, relying on the precedent in Ableman versus Booth, said, well, 100 years ago, the court said a state can undermine a federal law if it doesn't agree with it. See my point? It could be very easily used against you. All right? So this is why Ableman versus Booth was a good decision, that states do not have the authority to second guess and undermine the federal judiciary. All right? And certainly cannot declare federal law to be unconstitutional. All right? States, okay, has already decided earlier in Preak versus Pennsylvania, while they don't have to enforce federal law, they can't obstruct it either. And that's exactly what Wisconsin was doing here, folks. Okay? So yes, that is the case of Ableman versus Booth. All right? States do not have the authority to overturn decisions of federal courts. They cannot interfere with the operation of the federal courts, nor can they declare federal laws to be unconstitutional. All right? This is a very strong and solid precedent, arguably one of the best of the Tawney Court era. If you have any questions or controversies, please leave them down below, and I'll be happy to answer them for you. All right? And if you have not subscribed to my YouTube channel, I humbly ask that you do so now. You won't regret it. Just hit that little red subscribe button, that little bell, and we'll be in business. Take care. Stay safe out there. And I'll talk to you at the next bite. Take care. Peace out.